Thank you everyone for joining us. This is Business Borrowing Basics series. This is episode 2 of the series. And to start off by introducing our panelists, start with Phil Buffington, a partner at Balcom Bingham. He's part of their banking and financial services team. We have Andrew Hutchinson at Much Sealist, practicing as a special counsel debt finance attorney. And finally, Michael Weiss, a partner at Weiss Burney, who represents both privately and publicly held entities in various business and commercial transactions. I have the pleasure of being your moderator today. My name is Kate McAtee, and I'm in the corporate practice group at Duane Morris. You can read more about us on slides 42 through 45. We will not be going in the slides in order. We are intending this to be more of a conversational presentation, just like all of the other Financial Poise webinars. And we would like to recognize National Law Review, which is our co-producer for the series. National Law Review is a premier legal news website offering in-depth analysis on a wide variety of legal and business topics. You can read more about Financial Poise on slide 47 and more about the series on slides 7 and 8. This episode there's additional info on slide 6. And so now that we've done our introductions, let's get started. We'll start off by talking about Ethan and his business. Ethan is a small business owner. He's looking to obtain his company's first business loan to fund the growth of his business. When he received a proposal from his prospective lender, it included a bunch of fees that he didn't remember being mentioned. He only remembered that his contact to the bank spoke about a stream rate of interest on the first couple of calls. Ethan would now like to better understand the price of his loan, including what a stream rate of interest is. So Michael, could you explain what that is and generally what fees are more typical in the market and which are not?
Sure. Good afternoon, everyone. Thanks for having me again, Financial Poise webinar. A stream rate of interest really means a few different things depending on the context. In its simplest form, stream rate of interest is basically interest being paid on a monthly basis on either a term loan or a line of credit. So in addition to a repayment of loan principal, which we like to refer to as amortization, there's also interest being paid on the outstanding principal balance of a loan. Some loans can be interest only for a period of time. Loans may have different amortization schedules, but in addition to a principal payment, or even without a principal payment, there's a payment of interest which continues until the loan is paid in full, based on some balance. And it can get very complicated, which our webinar, maybe in future webinars, there's interest rate swaps, there's different types of, there's fixed interest, there's adjustable interest. But streaming interest means you as the borrower, you're going to be paying interest, all the time until the money's paid back. I think most business owners and borrowers understand that. We all have our home mortgages, and we know that those are combinations of interest and principal, and there's also a tax escrow, but that's not always something different. So I think most borrowers and business owners will understand that there is interest paid along. Fees is where it gets a little tricky, and I think our panelists will agree. Every bank is a little bit different with fees, and every product is a little bit different, and the numbers are sort of all over the place. Starting with one of the fees on most loans is called an origination fee. We also like to refer to that as points. You're borrowing, $1 million, for example. If your fee is 1 point, well, that's, a $10,000 fee. If I did my math right, I think so. And sometimes that could be negotiated and sometimes not, but that's a pretty typical fee and an expected fee. But there's also other fees, such as a packaging fee, an underwriting fee. And some fees are paid at the beginning of the process, maybe even before the loan closes. Bank may say, hey, we're going to have to do all this work and underwrite this loan, and you may decide, to go to a different bank or not take the loan. So we want to charge you hypothetically $5,000 underwriting fee because we have to have our folks, examine your business, examine your file. Sometimes that can get paid at closing. Sometimes it's paid before. Banks love fees, so no offense to my banker friends, where I have many, but more and more in times where I'm told the profit on the credit portion is not that great. The fees sort of help the bank recover some costs or make some profit. There's also application processing fees, um, uh, and um, other type of pre-closing fees, with all sorts of different names. Review fees I've seen, um, and so forth. And then there are, in addition to fees pre-closing or at closing, there's ongoing fees. There is packaging fees, which could be in the beginning. There's annual fees. There's late payment fees if a payment is late. There's NSF fees. So I think that the takeaway is that there's as a borrower, you're going to be paying a lot of fees. It's best to ask and get disclosure. And I know we're going to talk about disclosure in a minute. I've always felt in the consumer sense, disclosure is. I know Andy's going to talk more about the regulatory environment, but it seems in the consumer context, fees are disclosed more and more readily available, even though they're sometimes hard to find with all that paperwork. In the commercial world, they could be disclosed in a loan commitment letter or some bank documentation, but it's great to ask, and understand what is going to be paid and what not. And I would advise my borrower clients, get an email, get it in writing to see what all the costs are of this loan, because it's going to be more than just your principal payment. I had a borrower just the other day. We're amending a loan, and he was just sort of complaining to me that, boy, the deposit control account fees, the DACA fees, he said, those are really, really expensive from this bank. And he was a little bit surprised, and sort of a perfect example of you have to ask up front. And even then the bank can change them. So lots of bank fees out there.
Okay, great, thank you.
Caitlin, can I just ask Michael one question? I'm not sure that you mentioned origination fees, but in your experience, don't you see origination fees being negotiated in some instances depending on the borrower's credit rating?
I do. And there's so many factors that go into it. Exactly. Is it a new borrower? Is it an established borrower? What type of loan? What's the collateral? Is it real? Is the bank real eager for the business, Phil, with this a new relationship, or are they not? And yes, I know my business clients love to negotiate everything. So a bank may say, our 2% origination fee, our clients are always negotiating them. Yes, I do find more often or not they're negotiable. They're negotiable, even if a certain lender may say these are not negotiable. They find their way to go back to their board or loan committee, and they become negotiable. So at least in the commercial context, it's kind of the Wild West, and it's all just business. So yes, absolutely.
Great. Andrew, can you talk to us a little bit about recent trends you've been seeing around disclosure requirements by lenders regarding fees?
Hey, yeah, hi. Would love to. So, as Michael mentioned, historically, in terms of legislative protections, they've really just focused at the consumer level, right? Consumer financing. So think like a personal auto loan, home mortgages, things of that nature. But there has been a trend over the last few years, at least at the state level, to address what I think are really just concerns among legislatures that small business owners, small businesses need some additional protections when seeking commercial credit. And I'm not going to single out any particular financial product, but there are a small handful that are really kind of the target of this legislation. So there are a handful of states that over the past few years have adopted and enacted laws that require consumer-like disclosures in connection with certain types of commercial financings. These laws are really designed to protect the small business owner, right? So, for example, and I'll just focus on New York, because New York was one of, California was another state that adopted this legislation. Under the New York disclosure requirements, there are some pretty some pretty key exceptions that you should keep in mind, right? So the New York commercial financing disclosure law does not apply if the commercial financing is for or in an amount greater than $2.5 million. So, again, it's really kind of focused on very small loans that are being made to, or potentially made to, small business owners. The New York law also does not apply to regulated banks. Okay, so it applies to non-bank financing sources. It's a pretty broad definition that applies to open-end financing, sales-based financing. It also specifically applies to merchant cash advances and factoring transactions. And there are some other exceptions that we don't need to go into here, but if you're a small business owner out there and you're looking at taking out a loan for less than $2.5 million and you're based in New York, you should expect to receive by law sort of Truth in Lending Act like disclosures. And going back to what Michael said, this will really kind of formalize and standardize how fees are presented to a potential borrower. One of the bigger issues with certain types of financing transactions is that it can be really challenging unless you really kind of know what you're doing, or you engage counsel or some other advisor. It can be very challenging for a potential borrower to really kind of figure out, what is this costing me, right? There's fees, there's interest, there's other, there may be other expenses associated with the loan. And the purpose of these of this new legislation is to try to make that transparent and to try to mitigate against alleged abusive practices by some of the players in that space.
Yep. Caitlin, if I can, and Andy, I don't know how much you followed Rule 1071 and what's going on with all of that. There's a lot going on there, but that's certainly a rule that if you're dealing with some lenders, there could be a lot of compliance, not only for small businesses, but also for the lender. And that's kind of in a state of flux at this point in time as to how much that is. But it gets back to your point. It's a federal rule that's really to enforce fair lending laws for businesses.
Yep. No, that's definitely worth noting.
Okay, I'm gonna switch gears to Brianna, who is the founder of a new company. She successfully raised a friends and family round to develop a proof of a concept for detecting cybersecurity weaknesses in artificial intelligence. She's had several discussions with potential new clients, but as of now, she has no revenue. However, she needs money for sales and marketing. Phil, at this stage of her company, is Brianna able to borrow money?
Well, Caitlin, I will tell you, this one stumps me. Good, but good afternoon, everybody. But this one does, and I'd love any advice on this. My first point here would be is whenever anybody's looking to raise money on a family and friends round, make sure that you're raising enough money that you need, because in this scenario, if you're looking for money for sales and marketing after that initial round, it's going to be harder to come by than it would have been if you'd included it with the initial round. When you're developing a product, a lot of people can buy into that, and that's really where you ought to be expansive and consider what all revenue you're going to need or what all sources of capital you're going to need to really market your product. But to answer your question, there's the possibility you could go to a bank if you've got a personal relationship there, but what it's going to take is a personal guarantee or pledging some personal assets. There could be some grants out there. One of the things that I would suggest is going back to the same people you've gone to on the friends and family round and let them know that this is what you need to continue to market this product and where the development is. I hate to even mention this one, but I see people use credit cards to fund cash flow like this at times, which I consider to be one of the least attractive alternatives because the rates you can ultimately pay. And there are angel groups in most states where you can get in with organizations that bring angel groups in to look at investments. But again, at that point in time, you're still diluting your ownership because you're selling an equity interest. So, if you're fortunate enough to have been able to obtain a contract at this point, you may be able to use that as collateral to get some funding. But I will say, in my experience, this is a really hard time for somebody at that stage looking for sources of capital for those items to actually find. And going to your next question about economic development, unless you can go back and look at and really think about how you're going to do it, very seldom have I seen economic development authorities willing to fund based on marketing or anything like that. That's usually where you're going to actually come in, and they're going to give you some tax incentives by the number of people you're going to employ. So I hate to, I always try to be optimistic with this, but this is a really hard question and a really hard place to be. And it really goes back to making sure that you plan that initial friends and family offering to include everything you need. And what I tell people, if you think you need $100,000, then bump it to 125. Give yourself a cushion there because we never remember everything. And it's hard to go back to the same people, but it's hard to find money, in my experience, for these type items at this stage in your development.
I'll weigh in also for a minute. Yeah, Phil, I agree with you 100%. I think of some examples. If I refer like Brianna here to some of my lender friends, and Brianna, presents this story in the office, I may get a phone call from my lender contact saying, "Am I missing something? There's no business. There's no collateral." Now, the exception, I should say, not the corollary, is exactly what you said. I mean, if Brianna is willing to sign a personal guarantee and has a huge net worth and will pledge personal assets, different story. But let's assume that's not the case. Brianna then would probably self-fund. But I think the point is, um, it is, you know, for borrowing basics, borrowing is not an entitlement. Our lender contacts are running a business also, and they've got regulatory oversight if they're, regulated banks and so forth. And it could be a very cruel world. And I have seen excellent deals and excellent borrowers that have collateral and credit that for one reason or another are turned down by a bank because the bank is now no longer interested in that industry or so forth. So Brianna here just has a couple strikes against her. And I agree that startup is probably more equity. And I would say trends are it seems like it changes every 5 or 10 years where credit seems a little looser, then it's tighter, then it's looser. I think we're still in a relatively tight phase. The late 90s, I was around even before that, seemed like a little bit of a looser credit. But yeah, it's a real hard sell. Um, and now there are some non-bank groups. One quick thing I will mention, um, that will do equity, and will do loans instead of equity, mezzanine loans, and it's very common in deals with my clients where a certain investor is both a lender and an equity investor. They want to be in different priorities and different cash flow. So that's probably Brianna's better bet than a commercial bank.
Yeah, and Michael, I glossed over that. I mean, you're right. I mean, there are some investors out there that'll do that, that not only will lend, but invest equity. And one of the things we have to talk about is, what's your concept? Is it really unique and different? There are a lot of people out there trying to uh, provide these programs that can detect cybersecurity weaknesses. If she's got something really unique that she can sell somebody on, that may help her. But there's so many products out there now. I don't know if that would be the case, but you've got to keep that in mind. What's your product you're trying to develop, and how unique is it, and can you protect it from other people just copying it?
Okay, great. So Brianna's mentor, Mike, he owns a company that sells smart security cameras for both residential and commercial use. He's been fulfilling orders with some well-established clients for a few years now, but he just received his first order from Walmart. The size of the order is much larger than his available working capital. His current lender will not advance any money to pay his suppliers what they need in order to produce the products that Walmart has ordered. Are there any loan options? And this question's for Andy. Are there any loan options for Mike, or does he need to raise more money or go through another round of equity raise?
Thanks, Kate. So yes, I think there are some options for Mike. So, you know, without talking, I think we're going to talk about some of these later. So I'm not going to get into, refinancing or looking at sort of maybe longer term debt solutions. But one thing that came to mind is around purchase order financing. And this would sort of, to the extent that we're assuming, to the extent it's permitted under Mike's existing or by his existing lender. But assuming that's the case, a purchase order financing is an arrangement where your PO lender, your purchase order lender, would agree to advance to the supplier, which in this case, it sounds like that's really the issue, is that Mike doesn't have the cash on hand to pay his supplier in order to produce the goods that Walmart has ordered. So the PO lender would send cash to Mike's supplier to fund the Walmart purchase order. And without going sort of step by step, once Walmart pays for the purchase order, it would actually remit that payment directly, typically directly to the PO lender, not to Mike. And close the loop on that sort of short-term financing advance. So I think that's one solution. I'll admit I don't have a ton of personal experience with PO financings, but I understand that they can be somewhat expensive relative to other sources of financing. That's a good segue into, maybe another alternative would be for, I don't know the nature of Mike's existing credit facility, but if it does not include a revolver or a line of credit, perhaps that's another discussion that Mike could have with his existing lender, or maybe try to bring somebody else in to maybe do to provide some additional credit. I think that's probably under this fact set is probably the one of the better options is the PO financing. Other sort of short term or like bridge financings are really more sort of project oriented. They're not sort of designed for like short term liquidity or working capital needs. So it's probably not something that's a good fit under this scenario.
Okay, and Mike was able to begin initial discussions with a potential new lender, and that new lender sent him a term sheet for a larger line of credit. He likes the term sheet, he wants to move quickly so he can get the inventory needed in order to fulfill Walmart's order. How safe would it be for Mike to go ahead and make the inventory buy before he signs a definitive line of credit set of loan documents? Not Phil.
Well, I know we all have those clients that call us and say they've done something and want us to say it's okay. Quite frankly, this is one of those instances where I think we would tell them, don't make that order and until you sign the credit documents. And the reason being is the term sheet, as a general proposition, is not going to be enforceable. It's not a legally binding document. And so until you enter into the lending transaction with the lender, you don't know that you're going to be able to borrow that money. I would liken this to going to buy a car and driving off the lot before you got your financing from the bank to buy the car. If you wreck it, you're in trouble. And so is the person who lets you drive off the lot. So, this raises a lot of questions, but at the end of the day, if you've got a term sheet, then closing the loan and getting the credit documents in place is not going to be that hard of a process if you've already gone through that. And my recommendation would always be wait until you actually get those credit documents signed before you make that order and take delivery. Otherwise, you may end up in a default that's going to, again, have an adverse impact on your credit across the board if the supplier has to take that product back. It's to me, it's a simple answer. You just don't do it. If it happens, then you try to get the loan closed as quickly as possible so you can fund the acquisition.
Okay. Brianna has now been operating her company for a couple years. She's starting to receive some revenue, and her business continues to grow.
Caitlin, can I back up before we move on? Because I want to get Andy and Michael's thoughts and your thoughts on this.
Good.
There are a couple of cases out there, and if in fact that happens and the lender starts backing up on you, there are some cases. I think there's one in Delaware that talks about the duty to negotiate in good faith, and if the lender breaches, where you may be able to force their hand on closing the loan. And there could be some other equitable grounds. So don't panic if you've done it. The best course of action is to go ahead and close the loan. But if it can't close, then go back to the lender and let them know that you've relied on that term sheet and made this purchase. And hopefully that'll help you push everything across the line. I apologize for interrupting on that.
Yeah, no, Phil, it's a good point to make, and I would say, particularly if you are in a scenario in which you've received signed commitment papers from a lender that don't, well, that's a better set of facts than just having a term sheet by itself. It is in almost all cases going to include in huge font, this is non-binding, this is not a commitment, this is not, until the definitive docs are signed and executed, you don't really have any ground to stand on. But I agree with you completely. If you've got a signed commitment letter and you're in a scenario which the lender backs out at the last minute, then it's a different conversation.
Yeah, and I would just add, Phil, I think you were right on the money. You want to be sure. I'm sure you may have a lawsuit or some litigation, which drags on and on and on. And meanwhile, Walmart is not going to wait. I mean, they want their order fulfilled, or they're going to go probably somewhere else, and their documentation probably has strict date requirements. So to Andy's point, yeah, from my experience, there's also always caveats and disclaimers, and it's never over till it's over. So be real sure you've got your money lined up before you do that. The last thing you really want to rely on, especially in a new business, is I think is a dispute with the bank. But that's what we lawyers are here for, and there may be more going on, but more often than not, that's not a winning proposition.
Okay, thank you. So now as Brianna's business is starting to receive revenue and continuing to grow, she has started discussions to get a business loan. The lender has advised Brianna that it will have to require a personal guarantee as a condition to the loan. This is concerning to her because the entire reason that she formed the business as an LLC was to limit the liability and protect her personal assets. Michael, can you recommend some other lenders who would typically not include a personal guarantee as a loan condition? And also, oh, go ahead.
Yeah, this is a great question because you could tell by all my gray hair, I've been in the legal business and the finance business for a long time. But when I first started, I don't know, 35, 37 years ago, it never made sense to me, right? You form these entities, corporations, limited liability companies, to avoid personal liability. And here you are, like, signing a personal guarantee. Like, where's the disconnect? Well, the disconnect is, this is how commercial banks work, and not only commercial banks, most other lenders, except for I shouldn't say, mezzanine lenders, or there's all sorts of programs. I get involved with a lot of different HUD loans for real estate development. A lot of those are non-recourse, except for certain carve-outs, which it kind of goes beyond here. But initially I didn't understand that. So I would counsel Brianna to say, look, your lender, they really don't want your house, and they don't want your stock portfolio, and they don't want your children's toys or anything else you own. They want you to be really committed to paying them back. This is they do not want you to wake up one day and say, I didn't really like that business. I'm sorry I spent all of your money. I don't know, $200,000. I'm picking a name. I didn't like the business. It wasn't going that great. And that LLC that I formed has no other assets. and I'm really sorry. But we'll talk again for the next deal. As Phil and Andy would attest to, there would be a blank stare from the lender's face, and maybe some shock. So lenders, they want their borrowers committed. Um, so they will generally ask for a personal guarantee, especially for new businesses and kind of day in, day out commercial loans. There's lots of exceptions to this. If there's enough security or collateral where they're comfortable, if it's the type of industry or the type of loan where there isn't usually a personal guarantee. I could talk for an hour, and so could Phil or Andy, about different exceptions. But it's really more of a personal commitment statement as much as a collateral. No, so let's talk about default, which really, I'm not going off topic. I'm going into, so let's say there is a default. Lenders are very different. Some lenders will take a write-off, negotiate, forbear, and other lenders are scorched earth. We will try and collect every penny we are out. But I would counsel Brianna, this is normal. This is typical. I would counsel her even before she went into the loan that this is what they're going to want. That's why it's really cheaper money than equity, because if you take more, partners or shareholders, you're going to have to give up more. But it's less personally risky in many ways. So all these machinations go into a business analysis. Other lenders that won't require a guarantee, if you have I'll just name a couple. In many deals I work on with clients or myself personally, if an investor is also a lender, more often than not, there's not a personal guarantee. For certain type of government loans, collateralized by real estate for senior care facilities, it's one industry I work in, for example. There's no real personal guarantees, and there's many, many more. But just in kind of your startup business or everyday business, there's guarantees. One last thing I will say, guarantees can be limited. The borrower can negotiate, I'll guarantee 15% of the loan, or I'll guarantee something else. So there is a little bit of room for negotiation. But I will conclude by saying, just because you form an entity and have limited liability there does not at all mean that you are not going to have unlimited liability for a bank loan.
Yeah, if I can, Caitlin, and Andy, if you want to say something, because I don't mean to jump in, but I think it's really important, and I know all of us do this with our clients, and we do this if we're on the other side, and it's making a distinction between what types of liability we're talking about. In this instance, we've got a cyber business, and there could be a lot of liability associated there. So there's a reason for forming that entity. But when you start talking about borrowed money, what you're really talking about there is whether or not you're committed to your concept, where the risk allocation is going to go. And lenders are not in the business of taking a lot of risk on concepts that they're not the one really out there to get the benefit from. As Michael said, I don't know a lender out there that ever wants to take the collateral that they took to secure a loan. They'd rather have their money back so they can lend it out to the next person, as a general proposition. So it's really framing that concept of what liability am I trying to limit? And I'm not trying to limit the liability. Of course, I'd love to, but I'm not trying to limit the liability that's going to let me develop my concept and take it to market and make money on it. I'm trying to limit my liability to running that business.
So Andy, Phil and Michael, they just both mentioned limited guarantees. Can you talk about what type of limited guarantees there would be, and maybe the difference between what a joint and several guarantee would be?
Sure. Yeah, and I think we touched on a couple of them already, so I'll cover this quickly. So a joint and several guarantee, and I'll assume the guarantee is full recourse. So if there are multiple guarantors, just more than one, there could be just two. That means each of those guarantors is liable for the entire amount of whatever the underlying liability is. In this case, I'll assume it's just the obligations under the loan. And as a general proposition, the lender is not required to exercise remedies or seek recourse against either the borrower or another guarantor upon a default. The lender can just go straight to, guarantor A and say, hey, you owe me the full amount of this loan plus any other amounts that I'm owed under the terms of this credit agreement. I think Michael and Phil touched on, different types of guarantees limited to either a percentage or a dollar amount that's agreed upon up front. So the guarantors could say, hey, I'm only on the hook for X dollar amount, or 10% or 20% or whatever the case may be, and that's something that's a negotiated point. There are limited recourse guarantees. They're sometimes called no recourse. I think that's a bit of a misnomer, or a bad boy guarantee, as it's sometimes called, which just means that the underlying guarantee is only enforceable by the lender against the guarantor if in the event of certain pre-agreed upon circumstances, such as a bankruptcy of the underlying borrower, or if the borrower engages in like fraud, for example, is like kind of the classic example. But for the occurrence of those events, there's effectively no recourse by the lender against the guarantors. I'll stop there. I mean, we could probably come up with some other examples, but the typical guarantee that I see in my practice, if there is a personal guarantee involved with a commercial lending transaction, is a full guarantee. If there are multiple guarantors, it would be jointly and severally among the various guarantors. Although there's some variation, and the market, I think, if you're working in a different lending space or a different financing space, that there are maybe some variations and some customary sort of market trends that will dictate, kind of expected liability. But I completely agree with what Michael and Phil said. I think in the context of a commercial transaction, depending on the nature and quality of the underlying credit, don't be surprised if your lender is going to ask you for a personal guarantee. It's nothing against you. It's just the cost of doing business.
Andy, in your practice, and this may be helpful for the people attending the webinar, guarantees aren't always perpetual. I mean, can you kind of address the issue of what would need to take place to be able to get a release from a guarantee?
Yeah, so maybe the occurrence of certain milestones, whether they're financial milestones or project related milestones, could trigger the release of a guarantee. So that's something to think about. I don't tend to see as many of those, but I think it could be a creative solution in connection with a scenario in which the transaction that's being funded or financed kind of lends itself to a guarantee that falls away after the achievement of the milestone.
Okay, great.
I would just add, Andy, yeah, I agree with you. I do not see a lot of those either, Phil. I don't see a lot. I mean, the guarantee is out there, however negotiated, until the loan is paid off. Generally, I can't think of many examples where it's been negotiated away, with maybe the only caveat, if there's another transaction and loans are being restructured, which I with clients and deals, I feel like they're always being restructured. That is often the opportunity to revisit and renegotiate. Um, Especially if things are going well.
Right.
If things are not going well, obviously the borrower's not in a good negotiating position.
Well, but with a startup, you could really have the opportunity to have a company that was really accelerating. And if you were going to renegotiate, the only reason I bring it up is always keep this stuff in mind as an ongoing, because nothing's perpetual. You can always renegotiate when you come up for renewal.
Yep,
Okay.
agree.
If we can turn back to Ethan, his business is doing very well, but he is positive, but they're tight operating margins. He's currently leasing a warehouse space for his company, and the landlord of that space has provided notice that the rent will increase by 10% for the next lease year. It's about 4 months before the new lease year begins, but the terms of his lease require that he provides termination notice to the landlord 30 days prior to the expiration of the current lease term. He has found a warehouse that is for sale, which he thinks would be perfect for his company. Michael, what would his financing options be for an acquisition loan for this warehouse space?
Oh, the first comment I have to make, and when I read this paragraph, and I think that Phil and Andy would agree, 4 months is not a long time. And to negotiate a purchase agreement for the real estate and negotiate a bank loan, it really goes by quickly. So I would suggest to any borrower or business owner who's trying to think of, options is um, really get in front of the curve, because things take time and you're waiting on, you know, let's say the building maybe had an environmental problem and you're waiting on, a phase 1 environmental report. So, but let's assume in our fact pattern that that's enough time. I think we've really hit the sources. This is, I think Phil, Andy, and I deal with questions like this, and situations like this on a regular basis. It's very typical. I mean, great that the business is doing okay. And Ethan looks like, hey, I just want to save money. The rent's going up, and I did the analysis, and it's cheaper for me in the long run and better for my business to buy. The first option is go back to, go to your lender who knows you, and it has been, your relationship business partner, and let them know where we are and what you want to do. They know you, they'll understand, and they could probably move as quick as possible. So my clients, my legal business clients, like, you know working with their existing relationships, so they would be right in the office of the banker and saying, hey, here's the math, and here's our numbers, here's the projections, we want to buy this building. If that doesn't work, if the lender says, hey, we're at the max, we're not loaning you any more money, there are other options. There's other lenders that we've talked about. There's um, uh, if Ethan really wants to be an owner, I was going to refer to, sale leasebacks. Basically, when you own the building and you don't want to own it anymore, you just want to lease it, to pull up some cash. It's sort of the opposite situation that we have here. But it's just traditional lenders or non-traditional lenders. There's a lot of folks in the business of making loans secured by real estate. Real estate is about as popular an asset for collateral and security so forth. And when the lender, be it a bank or another lender, is going to underwrite this, they're really going to look at Ethan's business. If he's an owner occupied sole, and if he's having a warehouse, it's basically him. They're really going to look at his business in addition to the building. I mean, if Ethan's business is doing well and the projections are looking good, someone will will do the loan, probably with personal guarantees. But if not, the lender will consider, where is this building? Is this in a good area? So if Ethan's business does not succeed, is there someone else who can use this building? And any lender is going to ask for appraisals, marketing plans, business plans. But it's really the possible lenders are all the type of lenders we've mentioned so far in the webinar.
Okay, moving down the road by a couple years, Ethan's business is even more established. He's been in business for about 20 years and is at tens of millions of dollars in revenue. It's also majority owned by private equity. Currently, his business has an existing revolver facility and a term loan facility with a lender, and the lender has taken security on all of the business's assets. This prior year, his performance of the company has deteriorated just a bit. Ethan and his team are doing their best to address this from an operating perspective, but unfortunately, they're not getting the desired support from their lender. The business tripped a covenant, and now as a result, the lender has implemented reserves and put their company in a special asset group. How would Ethan be able to make payroll, Michael?
Yeah, this is never a good situation. And I got a call from a client, oh boy, about a week ago. And Andy and Phil have had these calls. So tripping covenants or going into default for any reason is usually not good. There's really only a few choices here. And well, let me start by saying banks initially for your first default, or if it's not a big deal covenant, they missed a loan coverage covenant, a debt service coverage covenant, a EBITDA covenant by a little bit, is it that big of a deal? The banks will often, in my experience, renegotiate a little bit, remodify. They may want something for it. The bank, meaning maybe they want more cash security in the bank, which is I've seen a lot, or some additional collateral, or they may want the investors in the business to put in more equity or more money. So more often than not, at least initially, the bank is going to work with the borrower, assuming it's not a major breach. And that's going to be my working assumption, that it's not a big deal, just tripped a covenant. So yeah, and there may, as the slides have showed, maybe a little bit higher interest rate. Um, it's sort of like a warning, I would say, to the borrower that you're kind of heading in the wrong direction. Um, we're not going to, call the loan and start defaulting you and um, um, disrupt the business. But you have to get to profitability, whether that's more revenue or less expenses. You may have to put in more equity, all of those kind of things. It's in practice, it's a slow evolving process. I think in theory, it seems like it happens quickly, but there's a number of different solutions. And the last thing anybody really wants is to go to litigation or really disrupt the business. Unfortunately, it does go that way sometimes, um, but that's where it goes. Now, say that sometimes a lender, again, they may want more equity. There may be an additional lender coming in to sort of separate the collateral, maybe, an equipment lender, a more expensive asset lender. So that's another solution. But it's usually more money from some source, and it's often the equity. That's been my experience.
Okay, and so Andy, Michael just mentioned an asset facility. Could you help Ethan decide whether he should maybe pursue a cash flow or asset-based facility?
Sure. So I think the answer really depends on the nature of the business, and the answer could be both, right? I mean, you could there are financing solutions that are split liens where you've got both an ABL revolver, and you also have a term loan that's provided by two separate lenders. But stepping back a little bit, so a cash flow facility is a financing that's based primarily on the company's projected cash flow. Its EBITDA typically is the measure, or revenue if it's for example, like an earlier stage software or tech company, not current assets. In contrast, an ABL facility is focused primarily on the value of the company's assets, typically your accounts receivable, inventory, and equipment. But AR and inventory are key targets for ABL lenders. They're looking for so-called quick assets that can be liquidated very quickly. Prime candidates for an ABL or asset-rich businesses. So, think manufacturing, wholesale, retail, those types of businesses. Cash flow lending can really be in any industry, but it's better suited for companies that produce and generate strong, consistent revenue streams. And that could include, again, sort of your early or late stage software and technology businesses. There are a couple of key differences in terms of sort of benefits or consequences of each. If your cash flow credit facility includes a revolving facility, that's going to be just a committed revolver up to a fixed dollar amount that allows the company to borrow, reborrow, repay, just subject to a very small handful of limited conditions. In contrast, an ABL revolving facility is going to be dictated by a borrowing base. And that borrowing base is just going to it's really the lever that determines how much a lender will advance based on the value of the underlying assets or the collateral. The reporting requirements for an ABL are going to be typically more onerous than for a cash flow facility. An ABL facility is going to involve monthly and typically weekly reporting on the status of the underlying assets. And I'll pause there because I know I think we're getting a little bit short on time, but just going back to what I said initially, is there better, worse? Not really. They're different. It really, the solution really depends on the nature of the business and the nature of the underlying credit quality.
Okay, and if he were to get a new lender to provide either the asset or a cash-based facility, this would require an intercreditor agreement amongst his two lenders. If Ethan was having problems getting the two lenders to agree to intercreditor terms, could you provide some insight, Phil, as to why this is so difficult and what you would suggest to Ethan in order to get the lenders on the same page?
I don't know if Phil may have dropped off for a moment. Just quickly. So, right. So if Ethan's existing lender is like, hey, you trip some covenants, I suspect that their appetite to dilute their collateral with another lender is slim to none. At least in my experience in that scenario, the incumbent lender is more inclined to be like, look, you can take me out, right? Ethan, if you've got another lender waiting in the wings to refinance this whole thing, great, take me out and you can just work with the other lender. But I think it's low probability that the incumbent lender would be interested or entertain, having an intercreditor with some other financing source in this scenario or this fact pattern. If it weren't distressed, yeah, sure, maybe. But in a distressed scenario, I don't really see that happening as a Bradco matter.
Okay, I'm gonna skip back to Brianna, given our time, but and so Brianna, AI is continuing to grow by the day, it seems, and so her business is continuing to grow. And she's looking for financing solutions, and she just has a lot of questions she wants some feedback on. The first of which is, one lender suggested a sweep account or a lockbox arrangement. And so, Michael, could you just explain a little bit what that is and how it could affect her business?
Sure. A sweep account or a lockbox is a financing solution, for lack of a better term, where lockbox, customers' payments will often be required to be sent to a bank into a lockbox. A bank is it's very common in some industries, especially where there's a lot of accounts receivable financing, and it's really important that the bank, the bank is comfortable that cash is there to pay the loan, the debt service. So a bank may require a lockbox, meaning that all cash um, um, paid by borrowers, doesn't have to be all cash, paid by, I'm sorry, customers of the borrower, go into the bank directly. And then the bank, can kind of monitor that this is how much cash we have. So we know how the business is doing. The money's coming to the lockbox. And that often is coupled with a sweep where in loan documents, the bank is authorized to basically take that money out of a lockbox and pay loan payments or other certain expenses. So it's really a control thing by lenders, that they want to get more control, and they charge for it because there's more administrative work to be done by the lenders to monitor, a lockbox or a sweep, even though, today everything's done electronically. Um, but that's really what a lockbox. Very common in especially sweeps in the healthcare industry, where there's a lot of customer cash going on, and there's no real inventory. It's all services. So it's very popular in some industries and not so popular in other industries.
Okay, and then we previously talked about asset-based loans being subject to a borrowing base, and usually a borrowing base certificate reporting requirement. Andy, could you explain a little bit about what that would entail?
Of course, thanks, Kate. Yeah, so that's a great way to tie out what we were just discussing. A borrowing base certificate is just a report that outlines a calculation of a borrower's borrowing base. What does that mean, right? So when there's a borrowing base that's going to be a key feature of your ABL facility or your ABL credit agreement. The borrowing base just means it's the maximum amount that's available for borrowing. It's based on the market value or the actual underlying value of the pledged collateral. So the AR, inventory, equipment, multiplied by a discount. And then it's going to be subject to an overall cap. So for example, the ABL lender may agree to advance funds against 80% of AR and 60% of inventory, up to a max of, say, 100 million, whatever it doesn't matter, but I'll just use 100 million because it's an even number. So the amount available on any given date, right, from the borrower or the company's perspective, is the lesser of the borrowing base, which is like the 80 and 60% we just discussed, and the maximum, maximum revolving commitment amount. And the borrowing base certificate is would be required to be delivered by the company in connection with any draw request or advance request under the revolving facility. It's also typically required to be delivered on a periodic basis in connection with other financial information. So, in my practice, like typically monthly, along with monthly financial info.
Okay. Thank you. I think
it's a little bit more work, I'll be honest with you, than for like a CFO or controller to prepare a borrowing base certificate. Michael shaking his head. Than it is to prepare, kind of just collect the financials, which you're doing anyways, and send those along. So there's more work involved with it, but ABLs are frequently used. Many of my clients use ABLs as just part of their primary capital structure. So.
okay. I think we're past our hour, so I want to be cognizant of everyone's time. I didn't see any questions come across. Any closing thoughts, panelists?
Bill, I think Phil had some closing thoughts.
My only closing thought is to apologize to the three of y'all. I have no idea what happened, but it just went dead on me. So I do apologize.
Technology, Phil, what can you do?
Exactly.
Look forward to the next one. Thank you, everybody. Hope
Thank
you
you,
learned a
everyone.
thing or two.
It was a pleasure. Thank you.
Thank you.